Supplementary list. Item number 1, pronouncement of judgment.
In view of the discussion on the report, no case is made out by the appellant warranting interference with the judgment dated 24/7/2024 passed by the learned single judge. Result, this writ appeal stand dismissed.
Apply, Your Lordship.
That's the last page.
Say it later.
Any mention? Item number 1.
Yes.
This matter I'm praying for some time, but this matter is under consideration for withdrawal. So, but that is not
Which one? This one?
item number 1.
Who's appearing?
Leonard Senior was
Where's
supposed.
Mr. Thakur?
Yes,
Where is he?
he was in VC just now, Your Lordship.
Anyway, you just inform him. Dr. M. Mozikal at DSGI has apprised this court that the matter is under consideration by Department for withdrawal. He prays that he may be allowed 2 weeks' time to obtain final instructions. Praise allowed. Mr. Pasantio, Vice
Thakur.
is present on behalf of the respondent. Just accordingly on sons.
Deeply obliged.
Item number 2.
Yes, Mr. Pandey.
Lordship, affidavit has been filed by the respondent,
When?
Lordship. Lordship, we don't see any reason to file a rejoinder to the affidavit. I'm praying if this
When
matter...
was it
Lordship,
filed?
what has happened is that we had served the copies to the opposite party.
You have not
Lordship,
filed it. It's not before the
Lordship,
court.
what has happened was the format in which they have filed, it came from Guwahati, is not acceptable to the registry, Lordship. It's technical.
Say that then.
Lordship, I'll just file it in the course of the day, Lordship. Today. I'll just
We
get
have
it
received,
rectified,
Lordship, the copy.
I will-
On
we have already-
11th.
Days that be given further 1 week's time to file the affidavit. To advance copy has been served to the petitioner in order to correct certain defects. Yes, days allowed.
I'll oblige.
You correct
Item-
it nicely because this bench won't sit another 2 weeks.
Item number 3.
But I'm praying for some more time for affidavit. It's for affidavit. I'm praying for some more time.
Was the second time's come only?
After motion, this is the first one.
Yes. Dr. Mozikal and DSCI pays funds allowed further
3 weeks time.
3 weeks time to file affidavit. This is the last one. So earlier मैंने interim order करा ना.
Hearing item number 4.
The SLP is still pending for Supreme Court.
Mr. Thapa is not present. Who's for the respondent?
But the matter is still pending with before the Supreme Court.
Last time submitted that is already listed on 24th of
Yes, my lord,
24th of March.
24th of March. My lord, on that day, my lord, despite notice, my lord, the custom did not appear. So, my lord, the Honorable Apex Court has issued notice again, requiring them to explain why they did not appear on that day.
Anyway, has informed the court that the matter is in pending consideration for the Supreme Court. This after 6 weeks.
But
Item number 5.
The MSCL's appeal, my lord, is
Yes.
I'm the respondent, my lord. His lordship has not made any error, my lord, because there are.
For the appellant or for the.
No, I am respondents, my lord.
I'm the appellant.
Yes. You ready the matter?
AG is leading this matter. He's on screen.
What error?
I said there's no error.
Oh, there's no error.
There's no error committed by.
Yes.
May it please, Your Lordship.
Yes.
Lordship, this is the issue where the learned single judge has directed the MECL to pay the wages in this case to contractual employees, and they are about 500 in numbers. And based on the principle, my lord, which the numbers is not correct, my lord. If I take your lordship to the impugned judgment and order.
Yes.
At page 31, your lordship will find the judgment and order of the learned single judge, lord, and the reasoning given by learned single judge.
Yes.
Page 31, precisely, lord. Kindly see page 31.
Yes. 31, yes. We got 31.
Yes, yes, Your Lordship. Kindly see what is the basis of the case and the petition also, my lord. But kindly see first part, my lord, paragraph 1.
Yes.
That petitioner MECL Progressive Workers Union is espousing the cause of regular contractual workers such union duly registered under the Indian Trade Act has approached this court with the application under 226 on behalf of the members who are employees working under the respondent Meghalaya Energy with a prayer that this court be pleased to issue a writ of mandamus directing the respondents to pay the members of the petitioners who are appointed as regular casual of the contractual employees. Lord, kindly mark. The prayer is who are appointed as regular casual of the contractual employees of grade 3 and 4 with the minimum pay scale revised from time to time with permissible allowances and such as dearness allowance as are being paid to similarly placed regular employees in areas of pay. So the prayer, if your lordship, what has been called out by the single judge is that contractual employees.
Yes.
Even the regular, the salary pay and allowances of regular employees. So, in effect, my lord, prayer is to grant equal pay for equal work in equal pay for equal work.
Yes.
Are similarly situated with regular employees, my lord. So, the requirement of law, my lord, in this regard is that first you have to prove that they are similarly situated and they are entitled to.
Yes.
They are performing similar nature of work. There has to be pleading to this effect. Then only the further examination of the matter has to be done, my lord. Now, kindly see the submission of Mr. Yumin on paragraph 2. Learned Counsel of the Petitioner Union has submitted that members of Petitioner Union are appointed in the sanctioned post, which posts are available in the regular category. Now, your lordship,
Sir, correct. Yes. Okay, yes,
the
continue.
regular cadre, however, they were appointed on casual contractual basis, having been services for 2 decades, etc., as Mali, sweeper, cleaner, pump operator, chowkidar, peon, teachers, and carpenter, my lord. So they have annexed the list of about 500 such persons, my lord, working on
contractual and casual.
Post of Mali, sweeper, cleaner, pump operators, and chowkidar, peon, teacher, etc. Learned Counsel also submitted that members of union are appointed against the posts available in regular category. My lord, kindly, there is no material whatsoever in the writ petition. I will take your lordship to the writ petition. Absolutely no material to show that they have been appointed at posts available in regular category. There is not a single material has been placed showing that they have been appointed against regular category. Means regular category means, my lord, these posts have to be sanctioned and created, and there is no sanctioned post or created post, my lord, and are also performing similar duties as was discharged by regular employees holding same corresponding post, my lord. So this is very important, my lord. It is based on 2 premises, my lord, that they are holding the regular post in the regular category and performing similar duties as was discharged by regular employees holding same and corresponding post. I'll take your lordship to the writ petition also in the contents. There is no material whatsoever except for a bold statement that they are discharging the similar, performing similar duties. Nothing has been done, which is the requirement of law. Paragraph 4. Again, para 6 of this petition was referred to when a chart was presented to show a comparison of pay as per Meghalaya Energy Corporation Regulation 2020 between the members of union and regular employees performing the same nature of work. This is the only material which is there before the learned single judge. Extract of few entries are not, for example, cleaner Mali. Now, existing pay scale, revised pay, ROP Milord of 2013, revised pay matrix is now monthly salary paid to members of union, last column. Your lordship may kindly have the last column of this table. Now, unskilled workers pay is mentioned, Milord, that this is the plus by the last.
Yes, unskilled, yes, we can see.
Yes.
Yes.
So, your lordship, the issue is, which calls for your lordship consideration, first issue, which falls for your lordship consideration is that in case the government or the government entities take a decision to appoint a contractual worker, whether the contractual worker will be entitled to pay scale which is payable to the similarly situated person, because contractual workers cannot claim the same pay scale which is payable to the regular to the employees who are regularly appointed against sanctioned posts. If I take this proposition to be legally correct, Milord, then in effect, whenever even for 6 months, a contractual employee is appointed for certain work, Milord, then the government will be bound to pay the pay scale which has been claimed by the petitioner. Milord, in my humble submission, this is not the correct position of law. I will place the number of authorities on that point. But first, kindly see, Milord, first column is cleaner Mali, Milord. In cleaner Mali, Milord, if the Mali who is working against the regular sanction post and he has been working from 9 to 5 or 10 to 5, Milord, and those who are appointed in contractual worker, Milord, they may come and go and they may not be performing same amount of work. They are not performing similar work, Milord, and still they have been. The Honorable Court has directed the MECL to pay the minimum pay scale to them, Milord, which is also not correct, Milord. Kindly see first column itself: cleaner, Mali, sweeper, Khalasi, Chaukidar, and Pew. So the names have been given in the first column, Milord. The pay scales have been given, and what is the last column will also monthly members of the union. So whether they are similarly situated or not, they are performing similar work or not, and whether there is any material for the level just to compare the work of a regular employee with contractual employee. That material has also not been placed, Lord. And based on that, if you Lord will kindly see paragraph 5 now.
Yes.
That the Learned Council has further submitted that members of the union, though appointed as casual employees, now there is change casual employees, the terms and conditions of service rules were made applicable to them, and even matters of transfer, same rules which is in place for regular employees is also applicable to them. If this environment also is not backed by any material, there is nothing on record to show anything, Milord. Now, paragraph, in this backdrop, petitioner union has placed a charter of demand before the respondent equal for work, prominently figuring in such demand to dismiss. So, Milord, their charter of demands, Milord, and that my learned friend, Milord, in paragraph 8 relied on decision of the Honorable Supreme Court of the State of Punjab, Jagdeep Singh, Milord. I will also be referring to this judgment extensively, Milord, and this judgment is in favor of the appellant before your lordship. Your lordship will examine it, and recent judgments also are in favor of the appellant. It is therefore prayed the petitioner that the relevant authorities be directed to pay the members of union minimum pay scale so and so. Now, my submissions have been noted, Milord. In paragraph 10, is not maintainable in the present form, wherein it is noticed that petitioner has filed on behalf of petitioners, albeit being members of union, but with different cause of action, where each member would seek relief to a specific set of facts and situation, and which fact cannot be clubbed together in single requisition. Milord, the contention is that if the members of union who are Mali and not Jugali workers. So Mali will claim that I am doing the similar amount of work as a member of union, and similar amount of work is also being discharged by the regular employees of the corporation. The members of union who is Mali will say that the minimum requirement for recruitment of Mali is 10th pass. I am also 10th pass. The members of union will also say that I possess similar qualification, similar responsibilities, and then only he can ask for that and do this identical work. Then he has to establish, my lord, all these parameters. Then only he can probably come to this honorable court, or this honorable court will direct the executive authorities to examine and pass appropriate orders if these parameters are met. And in my humble submission, not a single averment is there. So first contention which was raised, my lord, that all workers under the union cannot be treated into one. If your lordship will come back to the chart again, my lord, at paragraph 4, which is quoted by the learned single judge in the impute judgment and order, my lord. Paragraph 4, my lord, if your lordship will see the first column, is a designation. Cleaner, Mali, sweeper, Khalasi, Chowkidar, and...
No, me see what the classification we've done is because they're having a similar pay scale and they're all grade 4. Correct?
Yes,
Jugali has a different pay scale, so it's been classed separately, and pump operator different pay scale separately. And so that's the classification, if I understand correctly.
Yes, your lordship is right. Yes. What your lordship is saying that so my submission is, if you are member of the union is claiming that he is a pump operator, my lord.
Yes.
Now, if he is a pump operator, then he has to show that he is possessing the qualification of pump operator who has been appointed regularly. Okay. He has to show that he has the minimum number of works, minimum number of hours performed by pump operator who is appointed regularly. He has to show that all responsibilities discharged by the regular pump operators are also being discharged by the member of union as a contractual employee. Now, these materials are sine qua non for claiming equal pay for equal work, my lord. You cannot simply, in respect of all, say that no, they are performing equal the regular work, and therefore...
So you do one thing, Mr. RP General, see, the thing is that your main thrust of your argument is that the grant of equal pay for equal work has to be within certain parameters. It has to tick the boxes, like you say. So you give to us like the concisely where, like, where the boxes are not ticked by a single judge, whereby he has erred in granting the benefit of equal pay for equal work, where the parameters are not met. So you just argue on that line so we can concise the arguments. So you say that they have not met the parameters on point 1, 2, 3, 4, 5. And then let Mr. Yubin try to satisfy the court as those parameters are met.
Yes, my lord.
Because I think the whole issue is only revolves around that.
Yes, my lord.
Instead of reading the entire thing, what are the pleadings that you've made with regard to the parameters, whether they are met? And I did sing also, I think, which has been relied upon.
Yes. If I may give in just 2 minutes, my lord. 2 minutes, my lord.
Why? We'll give you more than 2 minutes. We'll give you 2 hours. We just hear
my lord, here, I understand the serious, I understand the anxiety of the Advocate General also in this case, because they will say that they don't have fund. That's why they are objecting. How can you curtail somebody's legal right just because you don't have a fund? No. This is exactly behind the point.
Please listen.
Yes. No, my lord, now...
Listen, the court has just expressed, like, a tentative, like you can see a roadmap as how we will, like, tackle this
my
case.
Lord,
correct. So only thing, that's
my lord,
we're
section
just
17...
defining the parameter. Let Advocate submit first. You'll have adequate opportunity. You please sit down, just hear him first,
Yes, my lord.
My lord, I'm not for a moment saying that if I am liable to pay in law, my lord, my financial condition can be no ground to deny the right to them, my lord.
Of course. That's a given.
The apprehension of, because if I am bound to follow the law, my lord, then your lordship will surely not say that no, you will not follow the law because you do not have money to pay them.
No, we're not on the fun part at all. Let's just,
So the point which the first point which I was canvassing,
the first point, yes,
that in order to compare the services of contractual employees, for example, working in Mali,
yes,
to a regular employee working in Mali, material has to be placed by the claimant that they are identically situated, not only on the basis of nomenclature. This is my first point, because there is no material whatsoever has been placed by the writ petitioner before the London Single Judge Law, saying that Mali of contractual employee is equivalent to Mali of regular employee law. That is the requirement of law. That is my.
So you say materials will be placed to show that not only the designation, but that not because of nomenclature, but the exact duties, right?
Correct. And that is my submission, Milord. This is my the precise submission. If I and second submission linked to this submission is, Milord, that there are these in the separate services, Milord, Mali, Jugali worker, all these cases cannot be clubbed into one, because Jugali worker may be a meter reader, Milord. All these. So what has happened, Milord? The union has filed and clubbing and declaring all these contractual employees to be equivalent to the regular employees, Milord. So therefore, Milord, there cannot be the mixture of cause. The cause of action cannot be clubbed. But coming back to the Milord pleading part, kindly see the writ petition itself, Milord, on this first part, Milord.
Okay.
Writ petition, Milord, starts from page 146, Milord. Very short writ petition, Milord. The fact, if you want, I'll skip the synopsis, Milord, and kindly come to the main page 155.
155.
Yes, Milord. So only 3, 4, 5 pages of writ petition, Milord, in effect. And kindly see paragraph 2, Milord.
1 second.
At page 155.
1 second. Yes. Paragraph 2.
That the members of petitioner who mostly constitute the lowest rung in the department have been appointed for last 2 decades, Milord. This is the general averment, Milord. Some were appointed in place of their deceased parents or spouse, while others are directly recruited as per the requirement of respondent. They have all obtained status and designation of long-standing casual workers doing a regular job, Milord. So this is the averment which my friend has made. Owing to their long service to respondent, it is humbly submitted that poverty has driven the members of the petitioner to accept low wages without any scale of pay, while fear of losing their jobs and compel them to remain silent for a long time. They quietly endured exploitation until they could not take any more, decided to form union for protecting and promoting their livelihood, addressing grievances of it, and securing wages for every member's, Milord, improving standard, Milord. Now, kindly come to paragraph 3, please, description of the parties, Milord. 4 is that since inception, the petitioner, the union have tirelessly worked for every possible way for welfare of the members by placing various charter of demand to the respondent number 3, including local paper. So that is a demand only, Milord. Now, paragraph 5, Milord, at page 157. The members of petitioners are appointed in sanction post, Milord. Kindly take note of the fact that a declaration has been made that the posts are sanctioned posts. Where is the material? On what basis you say that the posts are sanctioned? What is the cadre strength in respect of each other? Nothing, Milord. Which are also available in regular cadre. The nature and responsibility work are same for both. This is the statement made, Milord. A comparison of the post between two and the nature and the responsibility work illustrated below in the table form. Now, name of the post held by the members of the union, Mali, Milord, first column. Name of the post in regular category is Mali. So, maintaining and looking after the office of the garden. Mali will certainly look after the office garden, Milord, but how long you have been working, whether the post has been sanctioned or not, what are the terms and conditions, because if I will place those contractual the contracts also, my lord. Contracts are also different. Maintaining and looking after the office of garden. Sweeper, my lord, sweeping the office and compound of the office. You, as a contractual worker, you may come in the morning and go after sweeping, my lord. You post whether you are a good cleaner, my lord. This is the all material which they have placed before the learner single judge, my lord. Only similarity, even as per the petitioner, is the name of the post held by them as a contractual worker and regular. That is all they have given, my lord. And few now paragraph 6, my lord. It is stated that they are appointed against posts available in regular cadre performing similar duties and responsibilities as being discharged by regular employees. So this is the averment, my lord. What is the strength of a Mali in MECL or in distribution company? What is the cadre strength and whether they are working against the sanction post, my lord, because their case is that they are working against the sanction post, and we have denied that they are working against the sanction post. There is and this has been, and the next table which was quoted by learner single judge in the impugn order, my lord, will find designation and then same thing which your lordship has seen, my lord. Now paragraph 7, my lord. The paragraph 7 is one transfer order is quoted to say the service rules are applicable to the contractual employees, my lord. That begs to state that though they are appointed as casual employees, my lord, sometimes sanction employees against regular, sometimes casual employees, my lord, these expressions in service law connote different legal meaning, my lord. In the matter of transfer, they are governed by rules in place for the regular employees. They are also transferred from one division to another in terms of service rules, similarly to those. Now, sample of transfer order, my lord. This is all they have placed before the learner single judge. I mean, pursuant to the charter of demands, several meetings, and now they are talking about the demands, my lord. Besides that, there is nothing, my lord. And next, if your lordship will simply peruse the paragraph 8, 9, 10. These paragraphs relate to their demand only, nothing else. So the total, the complete, whatever material which has been placed for learner single judge is that the name held, the post.
That is all. I mean, these are all the pleadings that are contained in the petition.
Yes, this is all the pleading contained in the petition in a case of equal pay for equal work, my lord, where the lordships are aware that requirements are humongous, requirements are huge, where you have to demonstrate.
Yes, please continue.
Yes, requirements are huge, my lord. What I have done, my lord, is that I have prepared a note, my lord, on this issue, my lord. Your lordship, may I place this note before your lordship?
Virtually or physically? Oh, physically.
But before I take you to your lordship to the note, first again your lordship attention is drawn to the impugn judgment, my lord.
Yes, let's just examine the impugn judgment that we have not done.
Yes.
Yes.
I was your lordship.
Where the findings?
Findings, yes, your lordship. Kindly see my submission, how it has been dealt also by learner single judge. Lord, kindly see paragraph 11 at page 37.
Okay. Yes.
The paragraph 10, your lordship, the preliminary objection raised herein in this petition is not maintainable in the present form, wherein it is noticed that petition has been filed on behalf of number of petitioners, albeit being members of petitioner union, but with different cause of action, where each member would seek relief to a specific set of facts and situation, and which fact cannot be clubbed together in a single petition. So if Mali is saying that I am discharging Mali contractual work, saying I'm discharging the similar work, then he has to place the material in respect of Jugali workers will have to place similar work. Now, paragraph 11 below, that this has led to the para 5 of the petition, where an averment has been made by the member, meaning meaning many members of the petitioner union were appointed in sanction posts, which were also available regularly. The nature and responsibility of work both are being same. A comprehensive table listing the name of posts held by the members of union and also posts regular is also there. However, facts concerning each post is different, cannot be clubbed together in one single representation. Individual members of petitioner has a distinct cause of action against the respondent MECL. Paragraph 12. It is submitted that incumbent upon union, for that matter, the individual implies involved, that for making out a case of parity between two posts, there must be a wholesale identity between the holders of two posts. That is the law, my lord, for which a respective person is required to demonstrate the source of entry, qualification possessed, manner of recruitment, which is lacking in the petition, as only omnibus statement has been made by petitioner. On this singular issue, where there is a clubbing of multiple cause of action into single petition, same would render the not maintainable. In support of so-and-so authorities have been cited. Paragraph 13 below. Another limb of the argument advanced by learned counsel is that petitioner union is preferring this petition has failed to present the correct factual matrix of the case of members of union who were appointed beyond the number of sanction posts on need basis. Example of such posts being post of electrician, meter reader cum bill clerk, jugali worker, whose mode of appointment was on the basis of contract agreement, the pay which are being fixed on the basis of notification issued by Labour Department, the Government of Meghalaya, in line with Minimum Wages Act 1848, depending on the skills and ability. In fact, in addition to the said payment, the corporation has also extended number of facilities, etc. That is besides the point, Milord. So, point is, Milord, that we are paying them in terms of the statutory notification under the Minimum Wages Act. Now, the question also falls for your lordship's consideration is that in all cases wherever the contractual worker is appointed, whether the government or the public entities or the authorities within the meaning of Article 12 is bound to pay the minimum scale. In my humble submission, it goes against the statutory scheme. There is no requirement in law, Milord, to pay the. Now, paragraph 14, Milord, has again submitted when it comes to the drawing parity between two posts for the purpose of determination of equal pay for equal work, same would require a detailed analysis which only an administrative exercise can achieve, wherein various factors like nature of appointment, qualifications, quality of work, quantity of work, responsibility and accountability attached to such work has to be determined, which is not possible to be brought in the writ petition. To buttress this contention, the case of Union of India versus Indian Navy Design Officer 2023 SC or line SC 173 and in this case so and so were cited by learned counsel. Paragraph 15. The learned counsel has reiterated the petitioner union has not been able to present concrete evidence, cogent material to show that all the 31 posts indicated in these petitions are equal to any post held by the regular employee. In view of the presence of disputed question of fact, determination of which is best left to the executive, writ exercising the extraordinary would not adjudicate such disputed question of fact. The case of so-and-so is cited below. In reply, now the content. The petitioner union concerned that has occasioned discrimination in appointment in as much as 20 contractual employees were due course regularized in the respective posts, disregarding the other similarly contractual employees. Now, the contention is the regularization, Milord. The learned counsel has submitted that said 20 contractual employees whose posts have been regularized are the landowners or relatives of landowners who have donated the land situated in so-and-so places, Milord. This has been done on the strength of the MOU issued by personnel. So, the regularization of 20 contractual employees have nothing to do with the issue, Milord, of equal pay for equal work, Milord. And they are all different cases and based on different facts. Now, paragraph 17. Upon hearing the argument advanced by the parties, essentially centered the perusal of pleading, this court is made to understand that dispute is essentially centered on the allegation of the petitioner union that its members are being discriminated as far as their just dues are concerned, particularly areas of equal pay or equal work. There is no dispute that respondent authorities with regard to status of member of petitions as per employment is concerned. Milord, we have disputed, Milord. Learned single judge has noted my contention. Still, learned single judge has written that there is no dispute, Milord. We have disputed everything and that has already been recorded by learned single judge, Milord. That if the Lordship will paragraph 11 where my dispute is there of the impute judgment only.
Yes.
That so the learned single judge proceeds on the premise that there is no dispute, and the averments and the submissions which have been recorded by learned single judge clearly shows that we have disputed. That it comes to drawing parity between two posts, paragraph 14, once again, my lord, at page 39. Two posts for purpose of determination of equal pay for equal work. Same would require a detailed analysis which only administrative, sorry. So we have, then your lordship kindly come to paragraph 18 at page 14.
Page 14.
41, paragraph 18. There is no dispute by the respondent authorities with regard to status of members of petition union as far as their employment is concerned. In fact, the respondent would assert that said members of petitioner are contractual employees of the respondent appointed on need basis for a period of 1 year fixed under with additional financial has been shown. So, my lord, so if I take this paragraph to your lordship's consideration, my lord, what the learned single judge records would assert that said members of petitioner are contractual employees of respondent appointed on a need basis. It's not regular basis, what appointed on need basis for a period of 1 year with fixed pay in line with minimum wages act with certain additional financial property as allowed by 13. The respondent would, however, contend that claim of the equal pay would exist only when there is a wholesale identity between the holders of two posts as held by steel authority so and so, and further, even if the designation of the job is same, difference in educational, technical, as observed in the so and so has to take into account. Reliance has also been placed on the concept of equal cannot be applied to unequal or distinct classes. As such, daily workers cannot be equated with the regular workers. I am grateful that learned single judge has recorded. Now 20, the said respondent has further emphasized the point that equation of post of determination of pay scale primary function of justice, not the judiciary. Such functions requiring consideration of post of access, qualification, method of recruitment, and nature of duty, and court would generally not enter into the task of job evaluation, which is generally left to the expert bodies like the pay commission. These propositions are present in the so-and-so cases, my lord, relied upon the MECL to bring home the point that this instant petition has been preferred in a case where no right is maintainable, no fundamental right. Now, paragraph 21, my lord. On consideration of the proposition proponent by MECL, where stress is laid on the aspect of equation of post and determination of pay scale thereof, which requires proper classification best left to be done by an expert body, this court is made aware that the case of petitioner union is not for equation of post for determination of pay scale, but they are already existing same category of post, my lord. How did the learned single judge come to this finding, my lord? When I say we have disputed this aspect that there already exist same category of posts, for example, posts of cleaner or malik, some manned by employees who have been recruited to regular process and some appointed on contractual basis for 1 year, same being renewed from time to what is evident that there are two classes of employees, one regular, another temporary, performing same nature of work, the same determination and drawing two different set of pay scale is evident from chart. So and so, the authorities cited by therefore found to be not relevant in the case, my lord. And those authorities, my lord, I will place are squarely applicable, my lord. I will place those authorities one by one. The requirement is this finding, my lord, is that there is a chart, name is same, and therefore they are performing the same or similar work. It goes against the, my lord, in my humble submission, law laid down by the Honorable Supreme Court, and also the requirement to hold. 20, respondent MECL has also further contended that the petition is filed and represented not and maintainable as many religion. The members of union have separate cause of action. Each member have distinct cause of action. But equal for equal, it is required to demonstrate source of entry, qualification, etc. The Binod so and so was also in reliance was also placed in so all these judgments, my lord. And after that, my lord, paragraph 25, if learned single judge finding at paragraph 40, page 44, paragraph 25. The case of petitioner union could be best understood on the authorities relied in this regard. I have relied on this authority and I will cite this authority in detail, my lord. Jagjit Singh and relevant paras cited which are self-perusal. All the judgment noticed from paras 7 to 24 here and above pertain to employees engaged on regular basis. My lord, kindly mark this line. 7 to regular basis who are claiming higher wages under the principle of equal pay for equal. The claim raised by such employee was premised on the ground that duties and responsibilities rendered by them were against the same post for which higher pay scale was being allowed in other government departments, or alternatively their duties and responsibilities were the same as of other posts or different designations, but they were placed in lower scale, having been painstakingly taken through the parameters laid on this one, wherein the principle of equal pay for equal work was invoked, and considered it would be just and appropriate to delineate the parameters laid down by this court. In recording the said parameters, we have also adverted to some other judgments pertaining to temporary employees, also dealt with the instant judgment, wherein this court had the occasion to express the legal position with reference to principle equal pay for equal work. Our consideration has led to the following deductions. The principle of equal pay for equal work applies to cases of unequal scale of pay based on no classification or irrational classification. So if there is no classification or irrational classification, then the principle will apply. Otherwise, for equal pay, employees concerning with whom equation is sought should be performing work which, besides being functionally equal, should be same quality and sensitivity. These are the materials which are required. Federalism. So this law, paragraph 42.3 require that they have to not equation is sought should be performing work besides being functionally equal should be same quality and sensitivity. So even if it is a functional equality, but if there is no similar equality and sensitivity, the person may not be entitled to equal pay for equal work. I have taken the pain of showing the averment in the writ petition, Lordship has found nothing has been said on sensitivity, on the quality also, and nature of work, except that post manned by contractual workers and the regular employee, the nomenclature is same. In paragraph 44.3, Bhagwan Das case, this court recorded that claim for equal wages, duration for which an employee should remain engaged would not take any difference, and manner of selection. What, I can do, that I have got the compilation of authorities which have been referred. I will prepare a compilation, along with the note, and I will place all the judgments, and even if Lordship may kindly peruse my note also, which deal with these aspects, and this judgment, which learned single judge has relied, favors my case, and it is against the petitioner, and thereafter the learned single judge at paragraph 26, 27. The learned single judge has relied on alleged discrimination as per regulation is concerned, particularly the process of 20 implies the expansion offered by.
One second, Mr. Abhijan. Yes. You place your note and your.
Yes, note is my learned friend is carrying the note,
Yes, you. The compilation judgment. Yes.
Judgment also.
Where the compilation judgments.
And I will place the compilation also, which have been referred. If your Lordship may kindly see the note.
No, you made a compilation judgments.
No, compilation is not ready.
Oh, sorry, I thought that she had it in her hand. So it would be easier to refer.
No, one judgment is there, with latest judgment, but I would like to place. If you also will see my points.
No, we misunderstood. We thought that you had a compilation ready that you will do refer from that compilation.
If Lordships, if kindly see my note, which I have.
Yes.
If you Lordship kindly see, clubbing, first point which I have raised is clubbing of multiple cause of action into one single petition is impermissible and renders the instant writ petition non-maintainable. In support of that, my lord, I have relied on the judgments on next page, my lord. These judgments are, and I have culled out the relevant paragraph of the judgment also, my lord. Then your lordship will kindly see the second judgment, my lord, the second point at page. I'm sorry,
page 4.
Page 4, my lord. Yes, so now I have relied on the judgments, my lord. Union of India versus Indian Navy Civilian Design Officer. And the title of my point is extremely narrow in cases of equal pay for equal work. Now, in this judgment, also in paragraph 9, my lord, and the highlighted portion, it has been consistently held by this court that in plethora of decisions that equation of post and equation of salary is a complex matter which is best left to the expert body unless there is a cogent material on record to come to a firm conclusion that grave error had crept in while fixing the pay scale for given post and the inference was absolutely necessary to undo the justice. And then these judgments, my lord, the relevant paragraphs highlighted and put in the bold also, my lord. And then, my lord, kindly see 4, 5, after the judgment, my lord.
You quoted the entire judgment here.
No, wherever relevant paragraphs and bold portions also, my lord. And then you also will see the another judgment also, my lord. State of MP versus R.D. Sharma.
Yes.
Then, my lord, disputed question. And then, my lord, the judgment of Jagdeep Singh, prisoner's false.
Yeah, that's important because see, the honorable, the single judge has relied, has placed a lot of reliance on Jagdeep Singh. So there you have to distinguish why his findings, are not in sync or in consonance with the principles of equal pay for equal work. Yes.
Jagdeep Singh judgment, in fact, my lord, I have annexed with my writ appeal also, because that judgment is in my favor, and only one, if your lordship kindly come back to the judgment once again.
Yes.
Paragraph 25, lord, at page 44.
Yes.
And then I have read, my lord, the first paragraph 42, kindly see 42.3.
Yes.
The principle of equal pay for equal work applies to cases of unequal scale of pay based on no qualification or irrational qualification. The employees, the Ranjit Singh versus Union of India, for equal pay, the employees concerned with whom equation is sought should be performing work, which besides being functionally equal, should be of same quality and sensitivity. So 3 requirements, my lord. First, functionally equal, of same quality and sensitivity. Your lordship has seen what is the material which has been placed by the writ petitioner in the writ petition saying that they are meeting these parameters. No material whatsoever. Nothing. Except for saying that the nomenclature of the post is the same. And at best, if I argue against myself, my lord, I assume that they are functionally equal. But if they are not same, that requires a further elaboration, same quality, then also a same sensitivity, they are not entitled. So this is the first ratio of Jagdeep Singh, my lord. Now, 44.3, my lord. In Bhagwan Das case, this court recorded that in claim for equal wages, duration for which an employee would remain or had remained engaged would not make any difference. So if the longer period is also there, that will not make any difference, my lord. Also, the manner of selection and appointment would make no difference, and therefore whether the selection was made on the basis of or limited to a cluster, insofar as applicability of principle, and likewise whether appointment was of fixed limited duration or for unlimited duration was also considered inconsequential as per the applicability of principle. It was held that in realm of equal pay would be sustainable where an employee is required to discharge similar duties as regular employees and employees concerned possess qualification prescribed for the post, my lord. So the second requirement is, my lord, not only functional equation, the qualification is also required to be same. My lordship has seen no material whatsoever. In the above case, this court rejected the contention advanced by the government that equal pay for each question was not certain because employees concerned were in temporary posts and against posts which were sanctioned on a year-to-year basis. So the requirement is that if the employee possess qualification prescribed for the post. Daily rate casual labor case, this court held that the principle flowing from Article 38.2 of Constitution, government could not deny a temporary employee or at least minimum wages being paid to employees in the corresponding regular scale, although dearness allowance and additional as well as other benefits were casual workers. It was held that classification of workers skilled, semi-skilled, and skilled doing the same work into different categories for payment of wages at different rates was not tenable. It was also held that such an act of imply would amount to exploitation, and further the same would arbitrarily so. In the state of Punjab versus Devendra Singh, this court held that daily wages were entitled to be placed in minimum pay scale of regular employee working in the same post. Above direction was issued after accepting that employee concerned were doing the same work, holding the same post by applying the principle. In the state of Karnataka, a constitutional bench of this court set aside the judgment of High Court and directed daily wages be paid so and so, allowance being paid to regular employees. Importantly, this court in a very important distinction between pay parity, it was held that the concept of equality would not be applicable to issues of absorption and regularization, but the concept as held applicable was indeed applied to same issue of parity if the work component was the same. Judgment rendered by this court was modified by this court, and the daily wages were directed to pay equal in lowest grade of the category concerned. In concert, it is fallacious to determine artificial parameters to deny fruits of labor, and employee engaged in the same work cannot be paid unless another who performs the same duties and responsibilities. Certainly not in welfare. Such an action, my lord. After dealing with this aspect, my lord, paragraph 60, having traversed the legal parameters with reference to the application of the principle for equal effort in relation to temporary employees, daily wages, and ad hoc employees, contractual employees, sole factors that require whether the employee concerned were rendering similar duties and responsibility and were discharged by regular employees holding the same and corresponding post. This exercise would require application of parameters of principle of equal pay as summarized by us in paragraph 42 above. I will take your lordship. However, insofar as instant aspect of the matter is concerned, it is not a factual question. We say so because it was fairly acknowledged by the Learned Council of the State of Punjab. All the temporary in the present bunch of appeals were appointed against posts which were also regular cadets. It was also accepted that during the course of employment, temporary employees concerned were being randomly deputed to discharge duties responsibility which were same at the point of assign. Likewise, regular employees holding substantive posts were also post discharged by same. There is therefore no room for doubt that duties and responsibility discharged by temporary in present set of appeals were same as being discharged. So therefore, my lord, based on that, there was an admission that they are doing the identical work, and therefore the direction was placed. And kindly, the parameters which have been laid down is at 492, my lord, of paragraph 42. The judgment has referred to that judgment, my lord, which is cited here, my lord. And kindly come to page 434, my lord, of the compilation where Jagdish Singh is placed, my lord.
434.
434, my lord. The judgment of the
for a memo. Our appeal, okay.
Yes, entire judgment is placed, my lord.
The compilation.
In the writ appeal only, my lord.
Yes. We have got it.
And kindly come to paragraph 42, where the parameters have been laid down. 490 is the relevant page, my lord.
490.
490, my lord.
490.
Yes, ma'am.
490.
Okay.
And 42 is a Lord Civil Fine, 42.1. The 492.
Yes. Right.
In fact,
Yes.
492, the principles have been cut off from 491 for paragraph 42. This paragraph is relevant.
Yes.
But you've got the paragraph 42 at 491.
Yeah, the consideration.
Yes, the consideration heading of the paragraph. All the judgments noticed in paragraph 7 to 24 here above pertain to employees engaged on regular basis who were claiming higher wages under the principle of equal pay for equal work. Claim raised by such employees were permitted on the ground that duties and responsibilities rendered by them were against the same post for which a higher pay scale was being allowed to other government departments, or alternatively, their duties and responsibilities were the same as of other posts with different organizations, but they were placed in lower scale. having been painstakingly taken through the parameters laid down by this court, wherein the principle of equal pay for equal work was involved and considered, it would be just and appropriate to delineate the parameters laid down by this court. In recording these set parameters, we have also adverted to some other judgments pertaining to temporary employees, wherein also court had occasion to express the legal position with reference to the principle of work for it, and which has led to the following deductions. Now kindly see paragraph 42.1. First paragraph, my lord. The onus of proof of parity in the duties and responsibility of subject post with the reference post under the principle of equal pay for equal work lies on the person who claims it. So this parameter, my lord, I need not go beyond this. Onus, the question which squarely falls for lots of consideration, whether this onus has been discharged, except for saying, my lord, that the post in reference, that is the contractual post, is equal to the post for regular employees. So this onus, in my humble submission, has nowhere been discharged, my lord. The onus of proof of parity in the duties and responsibilities of the subject post with the reference post under the principle of equal pay for equal work lies on the person who claims it, and he who approaches the court has to establish that subject post occupied by him requires him to discharge equal work of equal value. That as referred in post so and so. So So, Lordship, this onus, my lord, has not been discharged at all. That's why I have taken your lordship, for the reason that there is what is the material which has been placed before the learned single judge to discharge this onus. So I am squarely covered by this. Now 42.5, my lord.
Yes.
In determining the equality of functions and responsibilities under the principle of equal pay for equal work, it is necessary to keep in mind that duties of two posts should be equal sensitivity and also qualitatively similar. So equal sensitivity, and those who are regular employees and those who are contractual employees cannot have the equal sensitivity. Differentiation of pay scale for posts with difference in degree of responsibility, reliability, and confidentiality would fall within the range of valid classification. Therefore, pay differentiation would be legitimate and permissible. The nature of work of subject post should be the same and not less onerous with the reference post. Even if the volume of work should be same, also the level of responsibility in these parameters are not met, parity cannot be claimed under the principle of equal pay for equal work. I put a question to myself, what is there in the writ petition or which shows that these parameters have been met? 42.5, 42.6, for placement in a regular pay scale, claimant has to be a regular appointee. The requirement is regular appointee. The claimant should have selected on the basis of regular process of recruitment. An employee appointed on temporary basis cannot claim to be placed in regular pay scale. This judgment is in my favor. The learned single judge has wrongly read this judgment in favor of the petitioner. Then 42.8. If the qualification for recruitment to the subject post vis-a-vis the reference post are different, it may be difficult to conclude that duties and responsibilities of posts are qualitatively similar or comparable. Where has the material been placed before the learned single judge that we are holding the identical qualification which has been held by regularly recruited Jugali worker or by Mali Milot? No material, and we have denied. Then 42.14, Lord. For parity in pay scale under the principle of equal pay for equal work, equation in nature of duties is of paramount importance. if the principal nature of duties of one post is teaching, whereas that of the other is non-teaching, the principle would not be applicable. If the dominant nature of duties of one post is of control and management, where the subject post has no such duty, the principle would not be applicable. Likewise, if the central nature of duties of one post is of quality control, whereas the subject post has minimal duties of quality control, principle would not be applicable. Lot 42.13 million. The parity in pay under the principle of equal pay for equal work cannot be claimed merely on the ground that at an earlier point of time the subject post and reference post were placed in the same pay scale. The principle of equal pay for equal work is only when it is shown that incumbent of the subject post and reference post discharge similar duties and responsibilities. And then 42.16 million, principle of equal pay for equal work would not be applicable where differential higher pay scale is extended to person discharging the same duties and holding same duties with the objective of ameliorating stagnation on account of lack of promotional ability. So there are a number of parameters, Milan, and in my respectful submission, Milan, none of the parameters have been considered by the learned single judge, and the learned single judge has brushed aside the judgments on singular basis, my lord, that they are not applicable. If your lordship will see that the judgments have been cited, if your lordship kindly see finding of the letter single judge on this aspect at page 39, paragraph 15.
Yes, page 39.
Page 39, my lord. And paragraph 14, my lord.
Page 39.
Sorry. Yes, my lord. Learned counsel has submitted 39, paragraph 14. Learned counsel has again submitted that when it comes to drawing parity between two posts for the purpose of determination of equal pay for equal work, same would require a detailed analysis which only an administrative exercise can achieve, wherein various factors like nature of appointment, qualification, quality of work, quantity of work, responsibility and accountability attached to such work has to be determined, and which is not possible to be brought out in it. To buttress this contention.
So it's just a recording of your submissions. These are the findings.
And then this is and the next submission, you know what I'm trying to say, Jagjit Singh at page 40. I have relied on this paragraph at page 40, and the finding, if you also will see,
Just try to read your submissions. Yes. Yes, yes, sorry.
43, my lord. 43, my lord. Second line at page 43.
Yes, the authority cited. Oh, he discussed
But
it.
that would not be relevant to the case in hand, my lord. If these authorities are on the issue of equal pay for equal work, these parameters, my lord,
Important.
the learned single judge has grossly erred in saying that these authorities are not applicable. These authorities are directly on this issue, my lord.
Yes.
Finding of the learned single judge on this point, my lord,
Yes.
is in my respectful submission is contrary to the principles culled out, my lord, and that is why I showed, my lord, that I not only relied, once again I will place that, my lord, paragraph 14 I have already placed, my lord, and Jagjit Singh, Subhas Rajeshwari, my lord, these judgments, if I take your lordship through these judgments one by one, they are squarely applicable. So those judgments, in my humble submission, could not have been distinguished by the learned single judge. Learned single judge on this ground, my lord. If you also will see the recent judgment of that is referred in paragraph 14, my lord. That Union of India versus, my lord, paragraph 14. The learned counsel has again submitted when it comes to drawing parity between two posts for the purpose of determination of equal pay for equal work, same would require a detailed analysis which only an administrative exercise can achieve, whereas various factors like nature of appointment, qualification, quantity of work has to be determined, which is not possible in so and so. To buttress this contention, Union of India versus Indian Navy Civilian Design Officers, paragraph 5.9, and you will also kindly see this judgment, my lord, of this judgment
Indian
by
Civilian,
Union of
Indian
of
Navy
India
Civil.
versus
Where is that
Navy
judgment?
Civilian. My friend will.
Yes, the quotation is.
If quotations are there, Milord, but I
you got a
just
copy?
wanted to place all these paragraphs, Milord. 5, 9, because probably all the quotations are. Yes, Milord, all these quotations are there in the judgment and in the my note also. The main question that falls for consideration before this court is whether tribunal and the High Court were justified in equating posts of JDOs and with CTOs and in fixing pay scale of JDOs equivalent to the CTOs. Paragraph 4 of my note, Milord. I'm sorry, paragraph 4 of my note, Milord. The main question that falls for consideration before this court is whether tribunal and High Court were justified in equating the posts of JDOs and CTOs and in fixing the pay scale of JDOs equivalent to the CTOs in utter disregard to the legal provision settled by this court in Catalogue decision to the effect that courts should not interfere with the complex issue of evaluating the nature of duty and responsibility posts and fixing the pay scale which task otherwise is based on by the expert bodies like pay commission. Before adverting to the rival contention raised by the learned counsel of the party, it deserves to be noted that power of judicial review of High Court in the matter of classification of posts and determination of pay scale is no more res integra. It has been consistently held by this court in plethora of decision that equation of post and equation of salary is a complex matter which is best left to an expert body unless there is a cogent material on record to come to a firm conclusion that grave error has crept in while fixing the pay scale or fixing the post and interference of was absolutely necessary to undo the injustice, my lord. So cogent material has to be placed, my lord. Then paragraph, the state of UP 10 versus JP Chaurasia while answering the question as to whether bench secretary of the High Court of Allahabad were entitled to pay scale admissible to the section officer, whether creation of two grades with different scales in the cadre of bench secretaries who were doing the same and similar work was in violation to right to have equal pay for equal work. This court observed as under. First question regarding entitlement to pay scale admissible to section officers should not detain us longer. The answer to question depends upon several factors. It does not depend upon either the nature of work or volume of work done by bench secretary. Primarily, it requires, among other things, evaluation of duties and responsibilities of respective posts. More often, function of two posts may appear to be same or similar, but there may be difference in degree in the performance. Quantity of work may be the same, but the quality may be different that cannot be determined by the relying upon averments in affidavit of interested parties. The equation of post or equation of pay must left to the executive government. It must be determined by expert bodies like they would also best just to evaluate the duty, etc. If there is any such determination by commission or committee, the court should normally accept it. The court should not try to tinker with such equivalence unless it is shown that made with extraneous consideration. In paragraph 11, the aforesaid ratio was followed by this court in Union of India versus Makhan Chandra Roy, against Secretary Finance versus West Bengal Registration Services. The claim of sub-registrar of West Bengal claiming parity in pay with Munsi on the basis of it was clear elaborately. We do not consider it necessary to traverse the case along on which reliance has been placed by counsel for the appellant, as it is well settled that equation of post determination of pay scale in the primary function of the executive, not of the judiciary. Therefore, ordinarily court will not enter upon the task of evaluation, which is generally left to the expert bodies like pay commission. But that is not to say that court has no jurisdiction and agreed to apply have no remedy if they are unjustly treated arbitrary state action and action. Court must, however, realize that job evaluation is both a difficult and not time-consuming task, which even expert bodies having assistance of staff with requisite expertise have found difficult to undertake sometimes on account of want of relevant data and scale of evaluating performance of different groups. This would call for a constant study of external comparison and internal relativity on account of changing nature of job requirement. The factors which may have to be kept in view of for job evaluation may include work program of the department, the nature of contribution expected of him, extent of his responsibility and accountability in discharge of diverse duties and functions, extent and nature of freedom of limitation available and imposed on him in the discharge of duties, extent of power vested in him and extent of his dependence on superior for exercise of power, need to coordinate with other departments. These parameters are required, my lord, and these parameters, in my humble submission, are sine qua non for giving equal pay for equal work, my lord, neither in the writ petition nor material annexed to the writ petition or by the learned single judge, my lord, these factors have been considered at all. At all, my lord. We have also referred to the history of the service and efforts, my lord, efforts of various bodies to reduce. Such reduction in the number of pay scale has to be achieved by resorting to broad branding of posts by placing different posts and having comparable jobs. Substantial reduction in number of posts pay scale must inevitably lead to clubbing of posts with rates which were earlier different and unequal. While doing so, care must be taken to ensure that such rationalization of pay structure does not throw up anomalies. Ordinarily, pay structure involves mind several methods of recruitment, level at which recruitment is made, hierarchy of service, minimum education, technical qualification, avenue of promotion, nature of duties, horizontal and vertical, public dealings, inspection implies capacity to pay. We have referred to these factors to emphasize that several factors have to be kept in mind involving a pay structure, and horizontal and vertical relatives have to be carefully balanced, keeping in mind hierarchical arrangement, avenues and promotion. Such a carefully evolved pay structure ought not to be disturbed as it may lead to failure. Then your lordship will kindly turn over the page, page 8, your lord, the highlighted portion, and not troubling your lordship with the entire paragraph. Because nomenclature is an issue, my lord. If lordship got the highlighted portion, a mere nomenclature.
Not a complex activity.
A mere nomenclature. Page 8, you know. A mere nomenclature designating a person as a carpenter or craftsman is not enough to come to the conclusion that he is doing the same work as another carpenter or craftsman in regular service. The whole case is the nomenclature is same, therefore I am entitled to equal pay for equal work. The quality of work which is produced may be different, and even the nature of work assigned may be different. It is not just a comparison of physical activity. The application of principle of equal pay for equal work requires consideration of various dimensions of a given job. The accuracy required and the dexterity that job may entail may differ from job to job. It cannot be judged by mere volume of work. There may be qualitative difference as regards reliability and responsibility. Functions may be the same, but responsibility must make a difference. Thus, normally the applicability of principle must be left to the evaluated responsibility. They are not matters where court can lightly interfere, my lord. And then on next page, my lord, page 9. Underline portion. Paragraph the evaluation of post 14, paragraph 14, my lord, underline post and determination of pay scale, the primary function is not of judiciary court, therefore should not. I have already highlighted this aspect of the matter, my lord. And the bottom of the page 9 also highlighted the classification of post, determination of pay structure, fall within the executive and court settlement cannot sit over this. And then on next page, my lord, state of MP versus R.D. Sharma. This court has consistently held that equation of post determination of pay scale is the primary function of executive, my lord. That point I have already emphasized a lot, my lord. Now, my lord, paragraph C, my submission number C on the same page. Disputed question of fact cannot be decided in writ proceeding. The issue concerning the evaluation of parity as between the contractual employees and regular employees has been held to be job of subject matter expert in the field. Said task has always been held to be more prudent to leave such task to equation post unless there is a cogent material record to come to the front of a grave error capture. So Subhash versus Rajendra Shivam, my lord, is the authority on that. Now, your lordship kindly see, petitioner has failed to plead and prove equal pay for equal work. Paragraph 6, it is submitted that the exercise of establishing wholesome identicity of the post and equivalence of work done by petitioner working on two different posts is a complex factual exercise where the petitioner must plead and prove the equivalence. It is submitted that being an exercise involving disputed question of fact, said exercise best left to executive. However, be that as it may, in the present case there is no evidence to show that 31 posts are equal to any post held by regular employee. In this regard, the submitted of judgment, my lord, Federation paragraph 9. Federation of All India Custom and Central Excise Stenographer India 9. The petitioner in the were personal assistant and stenographer, my lord. I have already highlighted. Kindly come to paragraph 9.3, my lord. While adjudicating upon the controversy, this court arrived at the conclusion that differentiation of pay scale was not sought to be justified on the basis of functional work discharged by petitioner at their counter, but on dissimilarity of their responsibility, confidentiality, and relationship with the public. It was accordingly concluded the same amount of physical work could entail different quality of work, some more sensitive, some requiring more tact, some less. It is therefore held that equal pay for equal cannot be translated into mathematical formula. And then on next page 10.3, and it was concluded 10.3 million that on the subject of equation post, matter ought to be left to executive million. I need not repeat. And then I have already referred to million 42.1.
Yes.
Point million 42.6. 42.8, one paragraph I have missed out, my lord, is paragraph 42.15.
Yes.
There can be valid classification in the matter of pay scale between employees holding posts with the same nomenclature, that is, those discharging duties at the headquarters, those working in institution. So even if you are having same nomenclature, my lord, assuming for the sake of argument that nomenclature is the basis for giving equal pay for equal work, my lord, then this cannot be done. And my lord, so far as we are giving the minimum and we are also giving them certain benefits. If your lordship, it's not that they have been left.
I want to see a sample of the contract they signed.
Yes, my lord, that your lordship is kindly. But before your lordship go to the point, kindly see the point E, my lord. I will place that sample of the contract also, my lord. That is there in the record. E, my lord, kindly see that last point on the note, my lord.
Where's point?
Appellant corporation as point E of my note, my lord. Last
okay,
page of my
sorry,
note.
sorry. Yes, point E.
Is there? Page number.
Yes.
Appellant has undertaken the following steps for benefit of the contractual employees. A. Enhancement implemented in the salary with effect from 2018 based on experience, tenure of service of casual employees in MECL. Percentage of enhancement of wages of the employees whose tenure of service is above 5 years but below is 5% of total amount of monthly wages paid. Percentage of in 10 years is 10%, is 15 years. Further additional benefit has also been extended for welfare of employees, which are mentioned casual leave, earned leave, maternity leave, payment of overtime, casual contractual. Hence, the claim of contractual employee that is incorrect and false, my lord. Several actions have been taken by the corporation in the interest of welfare of contractor in the corporation instead of appointing a 50-90 days basis and all these requirements. So, therefore, my lord, to say that we are paying the minimum wage, and the question which has gone for your lordship is that with regard to the nature of contract, my lord.
Oh, the ones he said there are two types, casual and contractual, correct? So let's see the contractual. Contractual will have to write, they'll have to be shaft out from the, yes.
198, my lord.
344, my lord. And before that, my lord, one more page of the repetition. Kindly see the MECL 53, page 53, my lord.
53.
Yes, my lord. The number of employees, my lord, the impact on our financial health also, my lord. That after 53 onwards, my lord, we have prepared a chart and placed, my lord. And the employees, number of the employees are, my lord, humongous, more than 700, 800, my lord.
You have 700, 800 contractual employees?
Yes, my lord, my lord. Because it's a meter reading, my lord. Every house now, smart meter is coming up, my lord. Lordship knows that smart meter and all these things are coming up. Probably
smart meters, you don't need to read them, or?
To me, smart meter will be, my lord, it's like prepaid meter.
Okay, so you don't need meter readers anymore.
In Delhi also what happens, my lord, that you have to recharge your meter on your own. If you don't recharge, you will not get the electricity, my lord, in advance. In fact, Noida it has happened.
Yeah, I'm ignorant about that. I don't have a smart, I have a ignorant meter.
In advance payment kind of system, my lord. Can you see the nature of if I...
So you mean to say that if it's like a phone, your charge goes off, it's disconnected?
Yes, my lord. Yes, my lord. They give some 5-4 days of time also, my lord, that you have to recharge.
And reconnection takes how long?
Yeah, otherwise you will not be. Because, so that is because financial health of these discoms.
Now the thing is that, what is the efficacy? Oh, it's better than the manual meter, or anyway, that's
Better,
beside the
much
point.
better, Milord, because you have to pay in advance, a kind of advance you are
Yes,
paying.
no. I mean, no. What
Otherwise,
this court's trying to say is that the efficacy, that means these meter readers who are working contractually or on casual bid, they'll be phased out.
or they have been, for example, they are checking 100 meters in a day.
No. What
In
this
which
court is saying, like now, if this new, call it system put to play, that means these people as meter readers also will not be required anymore. Okay.
there will be reduction, sometimes they come and check also, but whether meters are functional or not, proper or not, those things are there. But yes, number will go down. Kindly see page 170, the list of the employees which have been given by my friend's client, lot 173.
Yes. Yes, 173.
173, not. I'm just for this because then I'll take your lordship to the contract also.
7 people.
If your lordship will see 173, list of casual employees filing petition in High Court for equal pay for equal work.
Yes.
Now, is that casual employee, casual sweeper, if your designation, casual cleaner, then your lordship will see 6, then your lordship on 174, and the number, my lord, is that goes on, my lord, up to page, Lord, this goes on to 500 is there, 202, can you see the last number, which is at page
230. Oh my God.
231, 704, 720, and then
238.
738.
756.
236.
238.
So 745, 748, my lord, 237. No, even it goes beyond that.
Okay.
Just give me the last. 734, sorry, the last number is, my lord, 748, my lord. 756, 238.
And what's 267? Page 267?
239 is probably typed copy. 236.
No, sorry. Come 756.
From 239 to 267 are the type copy.
No, the amount of employees 756 are there. And it's okay.
748, my lord.
How are you getting 748? 756 given here.
In page 237, if you lordship will kindly see, 237, last number is serial number 748.
No, 238 is 756. See next page.
Yes, oh, my lord, yes. So, yes, sir, sorry, my lord, 756. So,
Yes.
this 756, my lord, will be given, either we will have to shut down or we have to recover from the consumer only. We can't survive also, my lord. That aspect also to be kept in mind, my lord.
What a name.
We are not exploiting them. And then your lordship will see 351 is the contract, my lord. Page 351.
Yes, 351. They were based on to see that, yes. 351.
Yes, my lord.
You've been
351.
next week. Second to
344 also.
matters
is there.
long.
Yes, 50.
Yes.
50, okay.
Yes.
351. Yes, my lord. This agreement is on 31st day of August made between so and so. And whereas
Oh, yes. Arrow 3.
data entry operator, paragraph 3, my lord. So sometimes we require and we not have been instructed to say that there are 1,700 contractual and 3,000 casual at present, my lord. 1,700 contractual and 300 casual employees engaged for 1 year and casual are 89 basis, my lord. 1,700, my lord. I have been instructed to say 1,700 employees.
Everywhere.
We are giving the so this is the contract, my lord, and they are governed by the they are governed. Post. There is no regular sanction post. So, in the light of what I have placed before your Lordship is the judgment of the Honorable Supreme Court and the case laws below. If it is held that all contractual employees are entitled to the pay,
Something else. Yes. How many contractual employees are there? You were saying 1,700. Where's Mr. Amit Kumar gone? He's finished his submissions.
My lord, I believe, I'm just assuming there's some network glitch, my lord.
How many contractual employees are there?
My lord, what I could hear from AG, he has received some 1,700, my lord. That was
1,700 contractual
1,700
employees.
and contractual 3,000.
3,000 contractual.
That was what I could understand from AG's submission. I couldn't actually note down.
1,700 casual.
My lord.
Yes, Mr. Yuban will know.
My lord, this number figure, my lord, according to me, does not matter, my lord. Here, the when a question of law is raised. But, my lord,
see, whatever court asks a question, just consider it matters.
My lord,
to say that it doesn't matter.
My lord, for that, my lord, then I'll have to take instruction.
No, just
because
asking,
whatever.
Yes, Mr. Archival, how many contractual employees are there?
1,700, my lord.
Contractual.
1,700 and 300 casual at present.
300 casual.
Casual.
300 or 3,000?
300 casual, 1,700 contractual, 2,000 altogether, my lord.
That's better, yes. Right. Okay. Anything else?
Nothing, my lord.
Yes.
This is all I have.
Yes. Mr. Yuban, you ready to reply?
My lord, if time permits, I would like to reply, my lord.
When is this bench sitting next?
Because just a gist of what I would like to reply, my lord.
The trailer of your replies.
So, my lord, so far, my lord, whatever I could gather, my lord, it boils down to one, that I failed to prove the honors, my lord. It boils down. All this argument, my lord, ultimately it boils down to that honors. I have not provided enough materials to say that the quantitative, the quality, the time, the risk factor, this I have not provided this. This is one point, my lord. The second point is, my lord, the quotient, the quotient or the principle of law of equal pay for equal work, my lord, has got two phases, my lord. One phase is the pre-Jagjit case, my lord, and the second phase is the post-Jagjit case, my lord.
1st of April. 1st to 3rd.
It was bench sits again. Also April.
3rd.
Then we heard the Archival General on behalf of the appellants list the matter for replies by the respondents on 1st of April.
My lord, 1st of April, I have a matter in the Supreme Court, my lord.
Third.
Third, I'm so sorry. 3rd will be traveling. So, my lord, any other date, my lord, in the second week? 7, 8, 9, any?
You know that the 7, 8, 9 is a dodgy week because there are many holidays coming. 7th is a holiday, 10th holiday, 12th, and even if I
15,
will come
17. 17 holiday.
Yeah.
14, 15, 16 have also been declared holiday.
16 will be fine, my lord, if subject to my lord's conveniences.
16 is the only one working day in the whole week, my lord, if I'm not wrong.
Yes, it's after that.
22nd.
22nd, my lord. Obliged.
You could finish it today.
Yeah, you take this one. Yeah, you take it.
Only this portion.
Wait.
You want me to correct?
Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 19, Your Lordship.
Number?
19. If Your Lordship can have this matter after 2 weeks, Your Lordship.
What's the matter about?
Notional promotion. Already retired, Your Lordship.
No objection.
No, Your Lordship.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 18, Your Lordship. Your Lordship, I humbly pray to take up this matter after 2 weeks, Your Lordship.
Not interested in the matter any longer.
No, we are interested, Your Lordship.
It's all right, Your Lordship. No objection.
Okay.
Your Lordship, similar prayer for item number 21, Your Lordship.
Where's Mr. D? He's on holiday.
No, Your Lordship.
Then?
We are not ready yet, Your Lordship.
Yes,
No objection, Your Lordship.
Highly obliged, Your Lordship.
Your Lordship, I beg to mention item 17 of the daily list.
No objection, Your Lordship.
it's part heard.
Part heard.
When after 1 week?
After
1 week?
Yes.
Okay, yes. Yes.
highly obliged.
Please, Lordship, I beg to mention item number 20, Lordship.
Number?
Item number 20.
Johnny Marbo?
Yes, Lordship. 1 week, Lordship.
Why?
Some difficulty, Lordship.
You have objection, Mr. Abraham?
No, no objection, Your Lordship.
Just after 2 weeks, yes.
Lordship, similar prayer for item number 26, Lordship.
26?
Yes, no objection.
No objection? Yes.
That's all I Lordship.
Supplementary list item number 1.
Yes.
May I please, Your Lordship? Your Lordship, this instant writ petition is against the order dated 19 October 2023 and 7 March 2025 passed by the Deputy.
25? Where's the order 25?
Your Lordship, the impugn order is at page 96, annexure 6, page 98, annexure 6, Lordship. Your Lordship, the operative part is in page 99, Your Lordship. May I read, Your Lordship?
Yes.
Therefore, this court find it fit and proper.
Is that a NOCMA matter?
Your Lordship, it is, Your Lordship.
It is, but then the case is against the registration of Sakhal Grey.
Yes, Your Lordship. Your Lordship, the brief fact of the case, Your Lordship, is that the petitioner belonged to the Sakagiri Aking. And Your Lordship, in the creation of the Sakagiri Aking and appointment of the Nogmas had been created since the year 1988, Your Lordship. An order was also passed by the EM, Your Lordship. And Your Lordship, the Nogma of Balangiri is the respondent, Your Lordship, the private respondent, Your Lordship. They had filed an objection and appeal against the order, Your Lordship, before the EM.
As the order recognizing you, registering as a NOCMA.
Yes, Your Lordship.
1988.
Yes,
Is that
Your
what
Lordship,
happened
1988.
after?
And Your Lordship, they had the same was rejected, Lordship, by the CEM. And then they approached the Honorable Guwahati High Court with a writ petition, with a writ appeal, Your Lordship.
From Baldangre.
Yes.
Then what happened?
Your Lordship, the order is in page annexure A, annexure 4, page 72, Your Lordship.
This is dated. Okay. Yes.
May I read the operative part, Your Lordship?
Yes.
The operative part is in page 87,
Page.
para 7, 87.
Yes.
This being the factual position, and it having been found that this land was in possession of the respondents from a long point of time, and as such the prayer for creation of Sakagiri Aking was duly considered by the authority. There is no illegality and or infirmity in the impugned orders. Accordingly, this writ application shall stand rejected.
So fine, there is a finding, then it's 1996. After this, what happened?
Your Lordship, after 22 years, Your Lordship, on the death of my predecessors,
Your predecessor was Nanjan Marak.
yes, Your Lordship.
Then
We had filed an application for appointment and registration before the EM. Your Lordship,
what is that application?
Annexure 5, page 88, Your Lordship.
Type copy is there?
90. Yes, Your Lordship. 90, Your Lordship.
Yeah. Okay, what happened to this?
Your Lordship, the Baladingiri Aking had filed an objection, Your Lordship. And subsequent had filed an objection before the CEM, Your Lordship. And subsequently, Your Lordship, this impugned order was passed, Your Lordship. That is Annexure 6, page 98. Yes, Your Lordship.
Well, how is this possible?
No, my lord, an application was wrongly or rightly has been filed, my lord, before the EM. That application has to be addressed, my lord. Now, my lord, there was a dispute. Now, my lord, may kindly see the order which was passed, the last paragraph, my lord. Both the parties are directed to file their written statement in regard to their claims of on the next date, my lord. And moreover, my lord, the other order, the next order, my lord, which is impugned, my lord, if my lord may kindly see, on page 171.
Yeah.
171, my lord.
Also, this deputy chief, remember?
Now, my lord, this order was passed. 171. This order dated. Order dated 7/3/2025.
Huh?
7/3/2025.
Your Lordship, this order was passed because the.
No, it's not there in this application.
Page 161, Your Lordship, Annexure 15. 161. Annexure
161.
No, in my copy it's written 170 and 171, my lord. It's written.
It's done to throw you off guard, yes.
My lord, if my lord may kindly see, my lord, this page 160?
169, Your Lordship.
160.
Page 169.
160?
169.
Then you kindly correct your paginations. You are young counsels, you should. Yes.
171, if my lord may kindly come to
15.
Yes, my lord. Yes, my lord.
Yes.
Now, what is the last order which was passed, my lord, that they are aggrieved to it? Both parties shall maintain status quo in respect of the dispute land until the final disposal of this case. That means, my lord, there is a dispute over the land, my lord. It's not as about a Nokmaship, my lord. It's about the land. The last order, my lord.
Where's the objection of this Baldingri Aking? Is it next year?
Lordship is,
then you should annex it to the court can determine
and moreover, my lord,
the same course of action was decided earlier on.
And my lord, if they are aggrieved with this order, my lord, they should have gone to the CEM, my lord.
Whatever it is, even then there's no hard and fast rule. This court can't take it up if there's a personal order of this court which had recognized them. But the thing is that, see, where's the application of that Baldingri? Objecting to your registration, to your application registration. You didn't get a copy of that. Did you get a copy or not of this application made by them? You just prepare properly and then you come back. We have to see whether the application is for Nokmaship or for because he.
But the order is saying about
Garu Hills has said that HDC said that it's not. It doesn't concern Nokmaship. Concerns some land dispute.
Yes, my lord. And moreover,
Your Lordship, if we come to page 160, Your Lordship, is the
application
miscase
of that for registration or for objection? Is objection to land or Nokmaship or registering Nokmaship?
regarding the land.
one more thing that my learned friend is not highlighting is 189, page 189, my lord. This is the order passed by the Deputy Commissioner, my lord. This order dated 9/12/2024. And the Deputy Commissioner has not been made a party, my lord, here.
Your Lordship, we are not aggrieved by this order, Your Lordship. We are aggrieved by the miscase order, Your Lordship, passed by the CM, Your Lordship.
CM or EM passed the order?
EM, not CEM.
Deputy CM, Your Lordship. Deputy CM.
So the appeal lies under
Deputy CM is in charge, he is a
EM.
member in charge of revenue.
Yes,
and
yes.
will rely to CM, yes. You take instructions, otherwise even you should annex the application made if you want some. I've heard MS ADCM issue notice Mr. SD present accept notice on behalf of respondents number 1, 2 and 3.
1 to 3 only, man.
Yeah, let notice issue to respondent 4 and 5 within 3 days. Stop. MS EDCM also prays his mail out to file and to file. You have that copy with you? To file by additional affidavit. Yes?
I'll see instruction, Lordship.
No, you get that application
yes,
made by that Baldangre, you file it. MS EDCM Learned Council Petitioner further please wait out to file additional affidavit to bring and record added materials such as the application made by the prior respondents before the Deputy CM, upon which the impugned order has been passed. Yes. This is after 2 weeks.
Your Lordship, I have filed. Your Lordship, I miscase.
We're not going to consult in this case right now. You first satisfy the court that you have made a case for interim orders. Yes.
Item number 2.
Wait, please, Your Lordship. Lordship, I'm being led by my senior counsel, Your Lordship, in this matter.
Yes.
Lordship, I'm being led by my senior counsel, Mr. Kipol, Your Lordship, in this matter.
Start. What is the motion matter? What do you want?
Lordship, can you let the matter come to me, Your
Interim
Lordship?
order?
No, Your Lordship.
Then what is the matter about?
This is with regarding to compensation, Your Lordship. After
From where to where?
from the
Where's
fisheries.
your prayer? Which page?
Page 15, my lord.
Mr. Chanda is okay. He'll manage on his own. Who's the for the state?
Yes,
Yes.
number 4, 1 to 4.
Yes, heard Mr. Counsel for the petitioner. Mr. S.N. Gupta's presence accepts notice on behalf of
Number 1,
1,
2, 3, and
1, 4. MSSB except MSSB.
For respondent 5.
Counsel.
Give me extra copy.
The standing counsel GHDC is on behalf of respondent 5. No further notice required. List out for 3 weeks for instructions affidavit. You need senior counsel for that.
Item number 3.
Yes. You want same order?
Your Lordship, I pray that this matter may be taken up at the end of the board.
But you, same order, you agreeable. Where's
Learned is appearing through VC.
who? You have any objection to the prayer made by them with regard to the schedule of fees being as per the?
No, I'll leave it to the court.
Yes.
But essentially, this was not an appointment from the panel. It was an appointment by your lordship under section 11.
Then we'll pass similar order.
Person reflects it.
Yes, we'll pass orders. Yes. Done.
Item number 4.
We need 1 day's accommodation for filing the submission notes of submission, Lordship. It is
You
ready,
no more
Lordship.
submissions to make orally.
Lordship, I was.
You have the order of submissions to make any further. If not, then we'll close it and you file and we'll pass orders.
Lordship, may I fix this matter tomorrow, Lordship?
Tomorrow?
Lordship. I'm praying, Lordship, if it can be.
Where's Mr. Paul today?
Tomorrow, Lordship, will be there, Lordship.
Yes, due to unavailability of the Senior Arguing Counsel, it has been prayed that the matter be passed over for a day. Stop. Next part is noted that the matter is the last leg of hearing. Parties to put in their respective notes of submissions by tomorrow.
By tomorrow, Lordship.
Because you asked for to put on note submissions.
Lordship,
Yes, tomorrow.
Item number 10 also, Lordship. So, item number 4, 5, 6, 7, 8, 9 and 10 are similar, Lordship.
Daily list item number 1.
Your Lordships are adjourning the.
We'll come tomorrow. You see, Mr. Venkatesh, let them just put in the notes on submissions. That's all. Yes, so we are concluding the hearing. We're not prolonging it further.
I was hopeful if I could get 10 minutes today, I would finish my part because my part is very limited.
Then we'll give you 10 minutes tomorrow. Tomorrow.
All right. Tomorrow. Great.
May it please, Lordship. Your pleading complete in this matter, my lord. Matter may be fixed for hearing.
See, the matter, some urgency in the matter.
Some urgency, my lord, but if your lordship will come to para 1 of the writ petition. Now, this is the locus and maintainability. They have stated that the petitioner is a society registered under the provisions of the Registration of Societies Act 1860, having its registered office at Maulanghat, Shillong. The petitioner is represented before this honorable court by its authorized treasurer. The petitioner society was registered by registration so-and-so. The petitioner society is also registered with the income tax authorities. Now, my lord, we have raised in para 6 of our affidavit, we have said that he has no locus standi and he has not annexed a copy of the registration certificate.
You bring it on the date of hearing.
Yes, because let them be put to notice, madam. Because in the rejoinder also they have.
We have filed a rejoinder, Your Lordship. Yes. So, madam will be fixed for hearing, Lordship will take it up.
No, it's fixed for hearing, but I think is that what Senior Counsel's objectives that regarding you have made a statement with regard to your registration, but then what is Annexure 1 series is what then?
Annexure 1 series is, my lord, you see, it's a PAN card.
Yes, Mr. Senior Counsel appearing behalf respondents number 6, 7 and 8 has raised an objection with regard to the locus of the writ petitioner, inasmuch as he submits that a copy of the registration under the Registration Societies Act not been provided at petition. Stop. Mr. Kharmuja, I pray they will allowed to bring the same record at time of hearing. This is for admission hearing after 1 week. Yes. This matter of admission hearing after 1 week.
Item number 2.
Lord, on behalf of the state, Lord, the affidavit is prepared and sent to the department, Lord. So I'll pray for a week's time.
Lordship, kindly see the last order, Lordship. Last opportunity was given.
Who's the officer concerned?
So, Lord, if that is the case, I'll try to file it today.
Let him appear tomorrow. Okay.
I'll file it.
Who's the officer concerned?
Lord, it will be the Under Secretary. Lord.
Who is he?
So otherwise, I'll file it. I'll try to file it today.
Saji, it's enough. I'm fed up of this kind of attitude. Number 4 is whom?
State, Meghalaya State.
Yes, let the director appear tomorrow. Who's the one signing? Or this code audited 5/3/2025.
So that is the thing, my lord. Either director or the. So, my lord, kindly allow me today only. I'll file it, my lord.
Granted final positive 2 weeks time for the respondent to file affidavit. The matter, when the matters appeared today, Mr. Kivu Prasaji has again renewed his prayer for further time. Stop. In these circumstances, the respondent number, who's phone number 4 to appear in person.
Lord,
tomorrow.
Kindly allow me today. If I'm not able to file, my lord. So I'll kindly allow me today.
As to why after not been filed.
My lord, my humble apologies.
This is enough.
My lord,
this court is tired.
So my lord, kindly allow me today. If we are not able to file, then
no. You appear tomorrow in person. You can file it today, you file it.
My lord, I'll file it today.
We can, otherwise we appeal person, we.
My lord, only that observation may kindly oblige.
No observation. Appeal person to answers to why affidavit have been filed.
Obliged.
Yes. Enough this latitude given.
Please, Your Lordship. Your Lordship, I'm praying that this matter may come up tomorrow for hearing, Your Lordship. We won't be filing any rejoinder.
Let it come after a week, Your Lordship.
Your Lordship, one of the petitioners in this matter, it's a connected matter. He's going to retire on Monday. It's his last working day.
No problem.
Your
No
Lordship,
issue.
today, Mr. Paul, he's not available.
So then whose fault is it? Court's fault, respondent's fault, counsel's fault?
Cases cannot be fixed at the convenience of.
Yes.
After a week,
For
Your
hearing
Lordship.
today?
It's
No, Your
for
Lord, order,
orders,
Your
Your
Lordship. Come after a week, Your Lordship.
Yes, MSB of Karanlang raise the matter B submits that no rejoinder will be filed. So I'll call this matter after a week for hearing.
Oblige, Your Lordship.
I'll oblige.
3 to 7, Your Lordship.
Item number 8.
May it please Your Lordship. Your Lordship, on the last occasion, Your Lordship, the petitioner, they had filed an additional affidavit.
Yes.
Your Lordship, on the last occasion, Your Lordship, the petitioner had filed an additional affidavit, Your Lordship, bringing on record certain documents which we had sought for clarifications. I'm praying for 2 weeks' time, Your Lordship, to file our affidavit, Your Lordship.
May I please, Your Lordship? Your Lordship, in this matter, Your Lordship, I'm for the petitioner in petition 285 of 2024, since the matter has been clubbed together, Your Lordship.
Item 27, Your Lordship.
Item number 27, Your Lordship.
So what do you want there?
The matter is fixed for hearing, Your Lordship.
Hearing today?
Yes,
Your Lordship.
But it's tag along, Your Lordship. It has to be
It's
heard
the same
together.
school?
Yes, Your
Same
Lordship.
school, Your Lordship.
The same MC, same school, Your Lordship.
Where's the petitioner in this matter? Where's he?
Lordship, the state has not filed the affidavit in item 8. So let them file an affidavit, Lordship.
No. See,
I have already filed my counter affidavit.
no. Where's the petitioner?
For the petition, Your Lordship,
Where's
for
he?
item number 8. Your Lordship, in this, the state haven't filed the affidavit.
No. Where's he?
As David.
He's not here in court today.
No, Your Lordship.
There are two other matters which are connected to this.
Lordship, the petitioner in item 8 is espousing the grievances of my learned friend, Lordship, which is that item.
The
27.
27, Lordship.
Is supporting
the petitioner in item 27.
Your Lordship, in item 27, they're
Can we
praying
see
for
the
the reconstitution of, not reconstitute, to approve the ad hoc committee, Your Lordship. And in item 8, Your Lordship, they've challenged the special managing committee that was constituted, Your Lordship.
So you two are loggerheads or you're supporting each other?
Lordship, kindly see the prayer in item 8, Lordship. Page 30 of the petition in item 8.
In item
Yes.
8, we are just challenging the order which has been issued.
To clarify this matter, Lordship.
1 second, yes. Let's see.
Prayer C, Lordship.
Direct the concernant, yes.
Lordship, just below, Lordship, and in the interim to direct the state respondents to allow the ad hoc committee, which was approved by order dated 22/10/2022.
Yeah.
So this ad hoc committee is that item 22, Lordship, which my learned friend.
Item 22?
Item 27, Lordship. So he's espousing the grievances of
Your
the
Lordship, in
the
my
petition and item
petition,
22.
I'm only aggrieved with the non-approval of my.
So this is a very loaded litigation, huh? These things should be stopped, yes.
Lordship, let the state file the
Let the
affidavit.
file
Will be
affidavit
filed,
then,
Your
yes.
Lordship.
Let
Last
Mr.
chance may be
Technical-
given, Your Lordship.
No, last chance,
day,
Mr.
yeah.
They file additional affidavit. Let them take proper instructions. Further 2 weeks time granted on the prayer of Ms. Ailingwa, Leonard Counts, General Government Advocate. 2 weeks further time is allowed for filing of affidavit by state respondents. Stop this matter together with don't PC number
Item number 27, 285.
285 also, which is the sit advertisement today, as the matter issue is similar. Oh, the matter issue is the same.
Yes, sir.
Yes.
Obliged, Lordship.
Item number 9.
So many to order the affidavit. A copy of the to be sent to the registry, to be handed over to the government advocate for the commission.
Your Lordship,
Lordship, in this matter will need kindly allow us 3 weeks time, Your Lordship. This is the third or fourth round of litigation now. Third round of litigation.
What's the matter about?
A police officer.
Dismissal?
Not dismissal, Your Lordship. He was never given an appointment because he was involved in some criminal cases.
Okay, for
3 weeks time.
As paid allowed.
Apply, Your Lordship.
Obliged, Your Lordship.
Item number 10.
Lordship, in this matter also I have a similar prayer, Your Lordship.
What's the matter about?
It's a service matter regarding for regularization, Honor.
Working with department?
Health Department.
Health
Department.
When was this filed? This was filed since December. Yes, as paid by so and so. Before the 2 weeks time allowed for affidavits. List thereafter.
Highly apply, Your Lord.
Item 11.
Your Lordship, in this matter, the respondent number 1 to 3 is supposed to file the affidavit. So I'm seeking 2 weeks time, Your Lordship, to file an affidavit.
You already filed? The fresh matter?
Yes, Your
What's the matter about?
Your Lordship is against the order of the CM, Your Lordship.
Nakuma matter again?
Regarding the condemnation, because the CEM has condemned the delay.
That appeal?
Yes.
Change that.
Then you file it fast.
Yes, we'll file it.
Yes, Your Lordship.
Mr. MSSD Sangma Vice, Mr. Are you standing counsel also?
No, Your Lordship.
Vice, Mr. SD, Learned Counsel 1, 2, 3, Mr. P. Sangma 4 and 5, 3, 4, allowed further 2 weeks time for affidavits. Interim order shall to the next date.
Item number 12.
Your Lordship, in this matter, the respondent have to file the affidavit, Your Lordship.
Your Lordship, I pray for some more time, Your Lordship. We've sent the affidavit to the department, Your Lordship, but then some more time is required to complete
You only asked for study leave, correct?
Yes, Your Lordship.
You received instructions?
Yes, Your Lordship. We require some more time, Your Lordship, to complete the departmental procedure.
2 weeks time as prayed, allowed for affidavit. Yes, thereafter and so.
13.
Obliged, Your Lordship.
My Lord, this is a contempt application. My Lord, in my humble submission, the petitioner has concealed the fact, my Lord, this is misrepresentation. There was the representation, my Lord, the impugn order, which Lordship has disposed of, was on limited direction. That representation has to be disposed of within 8 weeks, which we have done it, my Lord. And moreover, my Lord, the fact is that the petitioner in person has received that order of disposal, my Lord, which they have concealed. However, my Lord, I have a copy of the disposal, my Lord. So no representation is pending.
Who is this?
My Lord, she is the second wife of a deceased employee of
Whatever
the...
it is, why have they concealed this?
So, my Lord, it was, we have found it from the record that she has, the order was received in person. There was no requirement for postal. She came to the office itself.
Let's see that. You take instruction. See that the petitioner will have to pay exemplary costs, not the respondents.
Yes,
If what is saying is correct. Yes.
I can produce a record, my Lord, if need be, where her signature is reflected also. My Lord, the prayer was 50%.
Take down MS Arconi today. MS Arconi Learned Counsel for the respondents today has produced a communication dated 4th November 2024 to show that the representation of the petitioner has since been disposed of as per the orders, as per the order of this court. She submits that this fact has been suppressed by the petitioner. Stop. What is your name?
E-Pajo. E-Pajo.
Like from MS E-Pajo, Meghalaya Council to obtain instructions this after 2 weeks. If it's correct, then you'll have some difficulty, or will be in difficulty.
Item 14.
You give her a copy? Yes.
Lordship.
Yes,
affidavit, Lordship.
We have not yet filed, Your Lordship. We
Lordship,
just want about 2 weeks' time.
Lordship, this matter, Your Lordship. The petitioner have considered the fake.
No, you have said that a lot. This a lot.
Yes, I have filed the affidavit.
The petitioners had actually resigned from the VEC.
Yes.
Lordship, I will take instruction, Lordship.
Yes.
See the annexure 4, Lordship. See, very clear. I just wanted to place before.
So dismiss your petition now, Mr. Marak.
Because
MR Sangma, right?
MR Marang, Lordship.
MR Marang, sorry, yes.
Page 24.
Yes.
Page 24, my lord. The petitioners, they have resigned because the FIR was filed against them.
It's at page 25, Your Lordship.
Then the page 25 is that they even make an agreement before the block development officer that they have compromised. This is a page 25. And thereafter election also was conducted. The election was duly conducted, page 30. We were elected by the job card holders. So all these documents are with the petitioners only, but they have never disclosed this document.
Lordship, I will take instruction, Lordship. If it is true, I will withdraw on the next step,
Whether you
Lordship.
need instructions or not. Yes. Why you have no because state has no affidavit date? The videos involved. I mean,
Yes, Your Lordship.
in the acceptance of
It
the.
is because of this resignation letter, Your Lordship. If Your Lordship peruses at page 25, the Secretary
See, when you
has...
said there, para 7, that no show cause inquiry. Now you resign by yourself.
Yes.
Yes.
But we just wanted to make sure if the President had also resigned, because there's nothing in the body of the resignation letter to show that the President had also resigned from the VEC, except the Secretary.
Now who filed this? The President Secretary.
He's the President and Secretary. This is the President. Sonalim.
But the body of the resignation letter only talks about the Secretary.
But both of them have signed. Secretary and President, they have signed. This is the President.
Where have you described who you are in the writ petition? Mr. Marak. You see the first paragraph.
Anything.
You have not mentioned anything. You have not mentioned who you are. Who's this Sonalin and who's this Jenny?
They only said it para 6. Or para 7. They have not mentioned anything.
See, you come by name and you not mention who you are also. Just see the petitioner job card holders. You did a President Secretary.
Lordship, I am the President, Lordship.
Yes. What's the name? Jenny
In para
and
6
Sonalin.
they have mentioned, you know.
Yes.
In para 6.
No. Yes. Huh?
Para 6 they have mentioned that pursuant...
Take action against Srimati Jenny. Okay, well. Yes, yes, Jenny and both of them are signed. President and...
Yes. President and Secretary, they have signed.
Signature is there, but the body of the resignation, so there was some confusion there, Your Lordship. Otherwise...
The video also passed an order.
In para
It's
6...
like a joint letter. See, some secretary, they are stepped down. I don't know if you are so. The other one is... Who's this blessed woman?
Then the letter of the video, page 27, after the
Yes, Mr. Mark, you take instructions.
Yes, Lordship.
Otherwise, it'll amount to... Yes, what? No? After the since been filed by the respondent 426, wherein documents have been annexed to show that one writ petition has since resigned. The approach is court stating otherwise. Stop. Mr. Nekpa will ever to obtain instructions as also sent on the file after it for the next date. Just after 2 weeks. You can
Lordship, may I just small submission? Lordship, only because now I'm the president and secretary. Now the BDU is giving the job that functioning as to the opposite party, that to the petitioner. That is what I got the instruction, because the job card holder to be function as a secretary and president. Because
why? Because of the case.
Because of the case. I'm the elected member.
That's your job to ensure that it is submitted by Mr. P.T. Sangma that in view of the pendency of the case, the respondent number, what's BDO?
BDO is number 123. This one.
Number three.
Number 3 has handed over the functions of the VEC to the petitioners. MST England AG to obtain specific instructions to regard if this submission is correct. And if it is so, corrective measures to be taken immediately.
Lordship.
Lordship.
Lordship. This matter, Your Lordship, I've taken this.
You're appearing for, entering appearance for?
For the respondent number 4, Your Lordship.
Number?
Number 4. Your Lordship, I will
four
file.
response only.
For the respondent number 1 to 3, Your Lordship.
Yes.
Your Lordship, I will file my power, Your Lordship.
Yes, MS EDCM has entered appearance today on the phone and such notice is complete. Stop. What do you want? You file
For
affidavit?
2 weeks' time, yes, Your Lordship.
Next para MSSD Sangma for response 1, 2, 3 and respond and MS EDCM for allowed 2 weeks time to file affidavit. Is there after? So.
Deep development.
16. Item 16.
Please, Your Lordship. Lordship, on the last occasion, the respondent number 1 was supposed to seek instructions.
Yes.
We're still awaiting instructions, Your Lordship.
On the interim prayer. Only that you were removed when?
I was removed on.
Long time ago.
I was terminated by impugned termination order 1701/2024, Lordship.
Where's Dr. Mozika?
He's on Lex, Your Lordship, before division bench.
When are you going to obtain instructions?
I have no proof
You
of
not
that.
taken any steps to obtain instructions?
We have taken, Your Lordship, but we didn't get the replies yet.
Because he's seeking.
There's an interim prayer as well, Your Lordship.
Yes, the MS Ember Chiang, correct?
Yes, Your Lordship.
Vice Dr. N. Mozika for response 1 and 2 has submitted that they yet to receive instructions in the matter. Mr. LCM Learned Counsel has retrieved submitted that the information and further submitted the matter is for instructions and for consideration of the interim prayer. Stop. However, as no instructions have yet been received, this after 1 week. It's expected next day the instruction will be received. We'll take up the matter next week. Yes.
Highly obliged.
Hearing. Supplementary list item 11.
Yesterday we could not do it because Dr. Mozika was not available.
Lordship, I pray that this matter may be taken up at the end of the board.
It's already at the end of the board now. This is yesterday.
Yesterday it was there, my lord. This was this last leg posting where his representation was turned down, my lord, saying that the choice postings that I had given, there's no vacancy there. So I only want to file a fresh representation, my lord. With their assistance, of course, as Lordship had suggested that.
The court suggested that let them offer you a choice of postings.
My lord,
to so you avoid the additional hassle of filing a representation and it being disposed of.
My lord.
Yes, matter was taken up today. The matter has been listed to its fixed matter on the issue as fixed matter, but going to stop. However, Dr. N. Mozika is unavailable presently. Stop. Next paragraph. The matter, the case of petitioner is for consideration of choice posting as last leg posting, which has been rejected twice. Correct? Twice rejected by the respondent authorities. In the course of hearing on the earlier date, this court had observed that as the rejection has been done twice, perhaps the respondents may, in the alternative, offer options to the petitioner to choose from. Upon this is matter of the 1 week, yes, for such instructions to be obtained by the learned DSGI. You offer him where he wants to go. Yes.
Item 22. 22.
May I please, Your Lordship? I'm making prayer on behalf of Mr. Dotto, DK Dotto, Your Lordship. He was not well and he just informed me over phone that 22 and 23, the connected matters maybe.
You want to argue over phone?
He just instructed me over phone to pray for adjournment, Your Lordship, only for today.
No objection,
Yes,
Your Lordship.
on behalf of the DK Datta, a prayer has been made due to not his illness. Just after 2 weeks.
Much obliged, Your Lordship. 22 and 23 both. Much obliged.
24.
But please, Your Lordship.
You ready with the matter?
No, Your Lordship, my learned senior is in courtroom 4, Your Lordship. He's having a matter.
What's the matter about?
Lordship, here what has happened, my lord.
Where's Mr. Deb? He's not here also.
No, Your Lordship.
Right, he's become the lead counsel, I think, Mr. Deb, in all your matters. Instead of Mr. D.
Here what has happened, my lord. An order was passed by the village court, my lord, dated 4/8/2021. Thereafter, no appeal was filed. So an application for file was filed before the chief executive member under Rule 53 of the Administration of Justice Rules, my lord, for execution. Thereafter, my lord, the chief executive member passed an order dated 19/9/2023 at page 39, my lord, annexure 6.
Yes.
Here, if I'm permitted to read, my lord, the operative portion.
Page?
Page 39, my lord. So, as per Rule 53, Sub-Rule 2, whenever an application is made under Clause B of Sub-Rule 1, that is paragraph 3, my lord.
Yes.
As per Rule 53, Sub-Rule 2, whenever an application is made under Clause B of Sub-Rule 1 of the aforesaid rule, the application is to be considered as decree, only which need to be executed keeping in mind of the spirit of CPC. This being the position of the case, I have tried to execute the decree by summoning the accused person respondents, but they did not cooperate and failed to appear in my court. Since all options have been exhausted, hence left me with no other option but to forward move this case to the Court of District Judge, Additional District Court, District Council, JHTC Tura, to take necessary legal action, including issue of arrest, warrant and detention in the civil prison for realization of the aforesaid fine amount in view of Sub-Rule 3 of Rule 53 of the Garhwal's Autonomous District Council, District Administration of Justice Rule 1953. By this order, I also urge the court to expedite the matter and complete the whole exercise at the earlier. Thereafter, my lord, this matter was forwarded to the Additional District Judge, my lord.
Yes.
Then, Additional Judge, District Council, my lord. Thereafter, my lord, the Additional District Judge endorsed the matter to the Assistant Judge, JHDC Tura, my lord.
Yes.
The matter, on numerous occasions, the court has taken the matter, my lord. Thereafter, my lord, out of the blue, the respondents, private respondents, file an application, and in view of their application, my lord, the chief executive member passed another order, my lord. That is annexure 8, my lord, page 43. If lordship have seen the petition submitted by the Sri Depilson Sangma judgment debtors filed under order 9 Rule 13 of CPC for setting aside ex parte order dated 19/9. It mentions not the heard submission of the counsel. Petition is admitted for consideration. Case is restored to file. Call for the records.
19/9/23.
No, it should be ex parte order 99/2023. So we are aggrieved by this order, my lord. After the matter was already remanded back, my lord, to the...
The private respondent has appeared.
Yes, my lord.
Who's representing him?
That was his representing, madam.
It's a matter of 500 rupees.
Yes, my lord.
Your Lordship, I humbly plead that
How much money you spend coming, has the client spent coming to court for realization of 500 rupees?
In fact, my lord, this actually what has happened, my lord.
Yes, sir,
This is in respect of a resolution passed by the villagers, my lord.
No, 500 rupees. What happened is that 500 rupees order was passed,
Yes.
imposing a fine 500 rupees on the private respondent.
Yes.
Right? So private respondent never paid you.
No.
500 rupees. So you filed for execution.
Yes.
And the CM said that it's best if the additional district court of
Yes.
the district council
Yes.
looks to the matter.
The matter is still pending there.
For 500 rupees.
Yes. But in fact, what transpired, my lord, is that a resolution actually was passed in the year 2006, wherein that resolution, the decision was taken by all the villagers, my lord, that they will safeguard and protect, my lord, the biodiversity of the Akhang, my lord.
That's fine. That's the point. But this digital amount of 500 rupees, you're insistent on extracting it from the respondent.
Yes, because they actually what has happened, my lord, just in view of that resolution, they're still going against that resolution, my lord. That is why an application was filed before the village court, my lord. Therein they have admitted that that they have gone against the resolution. That 500 was imposed. Yes.
They stay in the same village itself.
Yeah, they stay in the same village itself.
They're not bothered about the Samanda village code.
They're not bothered about it. But in the affidavit in opposition filed by them, my lord, it shows that they have filed an appeal also challenging that village court order, my lord.
What happened to that?
That is still pending, my lord.
Where's Mr. Deb?
Sir Deep is in lower court, Your Lordship.
Should never
Having
be
a
a
matter.
submission. You say personal truth is something.
But in view of the matter, my lord,
in the state can take place to the High Court.
But my lord, if I may submit, my lord, in view of that matter, my lord, the order passed
No, but then
18/3/2024 is illegal, my lord.
Because to hear them at least.
Yes.
Your Lordship, as the conducting counsel is in courtroom for doing the hearing matter, so I humbly pray
No,
the matter
he's
can
not
come up
the
after
Mr. Deb, you have to hear him also.
1 week. Your Lordship.
After 1 week, yes, due to the absence of the counsel with the respondents.
Oh, interim orders there, my lord.
Interim order gets next day.
Highly obliged, my lord.
25.
Please, Lordship, this order dated 19/11/2004. Nothing remained for consideration because the detailed order has been passed.
See, who's opposing you now? They disappeared. Order dated?
Order dated 19/11/2024 because it is stated that it can be disposed on the presence of the standing council. That was the only because the detailed order has been passed.
Standing council is not here.
Yes, it has been since from 2024, from November. It was just because they were not attending.
Yes, this court by order 19/11/2024 had observed that had ordered as follows. Court order. Stop. Today also, when the matter is taken up, standing counsel is not available. As such, in accordance with the order 19/11/2024, the matters is today also the standing counsel is present and is represented by MSSD Sangma. Stop. Accordingly, it is noted that there is no necessity for the presence of the standing counsel, and the matter stands disposed of in terms of the order above mentioned.
May I pray just some time frame may be given for because
it
this.
is expected that the gratuity amount be disposed.
Your Lordship.
Expeditiously. Yes. Next matter.
Your Lordship, this matter may come up after a while.
No, you just see the order.
Your Lordship, since the conducting counsel is.
You're not to blame. Don't worry.
Lordship, in this matter, Lordship, last opportunity was given for us to file the rejoinder affidavit. Our Lordship, because of the bereavement in the family, Lordship, we could not take instructions from learned
That was on
senior.
10th of March.
Lordship, I'm praying, Lordship, 1 week's time to ask Lordship for
Okay, you do
filing
one thing,
the
you listen
rejoinder.
for hearing.
Lordship,
This matter for hearing after 3 weeks due to the pressing, due to the compelling circumstances of the learned senior counsel, rejoinder is permitted to file a meanwhile.
interim may be extended Lordship, till the next
Order
date.
of any be to is extended to the next date.
Lordship, and your blessing.